Hello, good afternoon, everyone. Thank you so much for tuning in on this beautiful afternoon. This is my first time going live on this page. Please let us know if you're joining this live, comment live. Today, I have the pleasure of having attorney Adrienne Woods, bankruptcy attorney, joining us from New York, who is going to talk about the bankruptcy for business. I will let her introduce herself. Good afternoon, Adrienne. Thank you so much for joining me. You can go ahead and tell us a little.
Thank you for having me.
Sure. Go ahead and introduce yourself and let us know, what are you doing?
Sure. My name's Adrienne Woods. I'm a bankruptcy attorney here in New York. And I'm here today to answer questions about business bankruptcy.
Awesome. Thank you so much. I really appreciate your time. Can you tell us a little bit about what's bankruptcy for business? What does it mean?
Sure, absolutely. Bankruptcy for business, the discussion starts with a detailed conversation about what's causing the business's problems. So the financial advisor and myself would review the debtor's books and records, or the putative debtor's books and records, and discuss the issues with the client to determine how best to assist. So I kind of skipped over the basics though. What is bankruptcy law? I work in three areas: bankruptcy law, commercial collections, and commercial foreclosure. So today we're focusing on the bankruptcy practice, in which I assist individuals and business debtors in liquidating and restructuring their debts. So this can be done either through an out-of-court workout, or it can be done under chapters 7 or 11 of the bankruptcy code for a business debtor. Chapter 7 is a liquidation bankruptcy, and chapter 11 is, at least initially, intended as an effort to rehabilitate the debtor. Although sometimes a chapter 11 debtor will end up liquidating or even convert to a chapter 7 if it's determined later on in the case that a rehabilitation isn't feasible. So for a business, you start by looking at the books and records, which is a great segue into, Noura, what you do, because a lot of times the first person who realizes that there's an issue is the trusted advisor, right? So someone who's looking at the books and records and realizes that the burn rate isn't really sustainable for the business. And ideally, the conversation starts very early on when the problem is still on the horizon. And that way you can really get the best possible result. So in looking at the books and records, you determine, what is the problem? Is it a lease that you can't really afford anymore? Is it a contract that's not really favorable? And can these issues be negotiated out of bankruptcy or, in an out-of-court restructuring or workout? Are there multiple creditors? Is it a single creditor that's creating the problem? If it is, then you're probably best off trying to do an out-of-court restructuring or workout and to negotiate a forbearance or new terms or something to that effect. So then we work with the client. And when I say we, I mean, myself or whichever bankruptcy attorney and financial advisor the business ultimately decides to retain, to develop a plan. And it's done in conjunction with the client. It's always a dialogue. The bankruptcy process, in order to be truly successful, it really is a partnership with the client. And as bankruptcy lawyers, we're business people too. But, no one knows the business like its owner, and the synergy is really key.
Mm-hmm. So it doesn't mean a business owner has to go out of business if they have to do bankruptcy, right? Does it close the business? No. Okay.
Not necessarily. So sometimes, if you look at the rate at which the business is spending cash versus bringing cash in, and it's determined that it's not sustainable, sometimes it is necessary to liquidate the assets if you determine that, there's nothing you can really do either out of court or in court in order to restructure debts in a way that makes the business a viable entity as a going concern. However, if you start the process early enough, which is why I really, I encourage people to reach out early on and have the conversation, even if you're not really thinking about bankruptcy yet, because bankruptcy is a toolbox of things that you can do to help a business to recover in many instances. But as with anything, if you start the recovery process early on, it has more of a likelihood of success.
Mm-hmm. Okay, so how early do you think? Let's say you mentioned burn rates, that when the person doesn't have any more any more cash to cover their expenses. So how much should someone has in their account to cover how long? Then when you say, okay, this is the perfect time to come and explore your options and see if bankruptcy right for you.
So the answer is really a simple one: as soon as possible. And because the rate at which you can spend money is going to be specific for every business. It's going to depend, some businesses are seasonal. Some businesses, it's unlikely that you're going to make any money for several months on end, and then you have a boom period. So that's why it really is, when the individual business owner or trusted professionals see a problem on the horizon, go to a bankruptcy attorney and have the conversation, because the earlier the potential client comes to me, the more value I can provide. If the business owner comes to me before there's a problem, for instance, future problems can potentially be staved off, and by a frank conversation with your lenders. You can perhaps negotiate an extension of payment terms, reduced interest rate, even a period of forbearance, maybe, something with a balloon payment at the end if you think that the problems are temporary and really are solvable. It really depends on the lender, the client's relationship with the lender, the reason for the default, the type of default. Is it a monetary or a non-monetary default? The perceived viability of the business. So you can see that having the discussion before there's a problem can have a much better result. When the business owners wait too long to have the conversation, creditors lose faith in the viability of the business and in the owner's ability and perhaps even willingness to fulfill promises. Then it becomes much harder to negotiate. Sometimes negotiations can happen outside of bankruptcy. If the issue is really just a two-creditor dispute, for example, it's really a fact-specific inquiry that requires a fulsome analysis of the business, the amount of debt, the number of creditors, the type of creditors. Are they bank creditors? Are they employees? Are they trade creditors? And having the discussion can often save the business, its relationships with vendors, jobs and employees, and the owner's income, which is, of course, also important. It's hard to make the first move, but clients usually realize once they've done it, that it was the right move, and it's a toolkit. It's not a death knell for the business necessarily.
Mm-hmm. So I hear from some people that they say, I did it personally, and not for their business, but for their personal bankruptcy, they did it, and then they suffer for 7 or 10 years. They couldn't get any credit cards, they couldn't buy a car or a house. What would you tell them? Like, how is the bankruptcy different between the person and the business?
Well, I would say two things. So an individual bankruptcy, you can also reorganize an individual's finances in bankruptcy. And I think it's also important to remember that while bankruptcy does actually stay on your record for a number of years, and no, it's not a positive impact, but neither is having a substantial amount of debt. And that's going to impact your credit score too. So whether you're a business or an individual, addressing problems, you can't bury your head in the sand forever. And bankruptcy, when it's a necessary tool, is a very useful tool.
Mm-hmm. And who would determine what type of bankruptcy the business should choose? Like, is that the business owner, is that an attorney yourself, or is it the court that force one type of bankruptcy over the other?
That's somewhat of a complicated question. So the initial determination can be made in one of two ways. So in the case of a voluntary bankruptcy, meaning that the business owner determines that it's important to look into filing a bankruptcy, he or she would ultimately make the decision, hopefully in conjunction with trusted advisors, your attorney, your financial advisor, people who understand the bankruptcy process and can give you an honest assessment of whether or not your business is something that's viable as a going concern. If you're talking about, however, an involuntary bankruptcy, which also exists, your creditors can actually put you into bankruptcy. Once that happens, you can actually then convert to a different chapter of the bankruptcy code in some instances. But I think we're really more focused on trying to get the debtor or the business owner to sort of have that come to the table moment. And then if you're in bankruptcy and say, for instance, you file Chapter 11, you believe your business has going concern value. Creditors, the court, the U.S. trustee, the case can be converted by other parties. However, as a debtor in bankruptcy, the presumption as a Chapter 11 debtor is that you remain in possession and you remain in control of your case and your assets, unless it's determined that you're just not, unless, you know, a creditor or the U.S. trustee convinces the court that you don't really have a chance at restructuring. And courts are generally very patient. They want to see the debtors rehabilitate. No one wants to see a business go away. And more often than not, your creditors and, you know, your creditors want to see you succeed because they want to get paid. Vendors want to continue doing business with you. Employees want to keep their jobs. And banks generally aren't in the business of owning other types of businesses, right? They're in the business of investing money, loaning money. They don't want to own your store. So if they think you're a viable concern, then they will work with you too in many cases.
Yeah, that's good to know. And when would you say for the business owner, it's too late, I wish you came before, now I cannot help you anymore? Is that something that you could say to someone in some circumstances?
I mean, in some cases, yes. So generally when that comes to fruition, it's because someone really waited until they had no assets left to work with. I mean, if a business truly has no assets, and there's no ability to reorganize and there's nothing to do, in many cases, you know, a business owner can just essentially leave their keys on the table and walk out the door because the business isn't viable as a going concern and you don't own anything to distribute. And, you know, you've maintained all of the corporate formalities, so nobody's coming after you personally, hopefully. That's an option. But it's unfortunate because often it doesn't have to be the case.
Okay. So when would you say, like, what would you say to a business owner who thinks now, like, okay, I might not make it until after this 3 months or so, I wish I can do bankruptcy, but I'm so afraid, like, so what would you tell them? Like, what's your advice?
Ignoring the monster in the room isn't going to make it go away. There's a huge sense of relief for both individuals and, remember, small business owners, that it's very much like dealing with an individual bankruptcy, right? It's stressful. It's often something that they've put their heart and soul into, and nobody likes to see their dreams crushed, right? And I think that's generally the fear that most people have. But there is a sense of relief from confronting your problems head on. Bankruptcy and debtors have been, in my opinion, unfairly vilified as something that results from irresponsible behavior, lack of financial literacy, sometimes fraud. But in my experience, it's almost never true. And the individuals and the owners of the businesses I've assisted in bankruptcy have, by and large, been hardworking people who suffered some traumatic life event, either personally or in their business. And I work to remove the unfair stigma. And I believe it leaves clients feeling a lot better about themselves and their prospects for the future. The process of bankruptcy isn't as bad as people think it is. And the earlier you start, the better outcome you can have.
Awesome. If you have any question, leave it in the comments below. We'll come to it. We'll try to answer it before we go for the day. And so tell me, like, what would you, like someone might ask, like, okay, can I still operate? Can I still do business while I'm in court for bankruptcy?
Absolutely. So
Mhm.
as a Chapter 11 debtor in possession, you are still in control of your business, and you actually should be operating it, because remember, we want to keep cash flow positive. We want to continue. The idea is to rehabilitate the business. So we absolutely continue operating the business during a Chapter 11 bankruptcy. And the presumption is that it will operate straight through. And at the other side, fulfill its obligations as a debtor in possession and exit successfully.
How long does it take usually from the start until the end to do the bankruptcy? Approximately, I know that might vary, but
that's a very complicated question, because
uh,
it really depends on how complicated the case is. I mean, there are some bankruptcies that have literally been going on for decades. However, they tend to be the larger bankruptcies because, needless to say, bankruptcies need to be funded. For a small business, I mean, gosh, it's really very difficult to say. It could be over in a year. It could be over in several years. A lot of it depends on, your creditors, frankly. How much debt do you owe? What are the circumstances of the debt that you owe? How quickly can you file a plan that creditors will vote to accept if you're required to have a voting impaired class? I mean, it's really a very complicated question. But I would say that your bankruptcy attorney, in conjunction with a financial advisor, after thoroughly reviewing the situation, should have some sort of a general idea on how long it should take. But again, you don't know what you don't know. And whenever a case is progressing, things can happen that change the calculation considerably.
And how much could it cost someone to go for bankruptcy?
Again, it's sort of it's really very difficult to say how much it would cost for a small business to file a bankruptcy, because it kind of goes to the first question: how complicated is the case? It's generally done on an hourly basis for a small business. Individuals can sometimes file a bankruptcy for a flat fee, often, in fact. For a business, it's almost certainly going to be an hourly fee. And so, how many motions do you need to draft and file? How many court appearances do you need to have? Will the court approve everything at the first hearing, or will there be adjournments? It's very difficult. It's kind of like a ball of yarn. You just don't know the end sometimes until you're at the end.
So does the business owner has to go to the court every time that there's a hearing or something, or does the attorney, can take care of that? Or
so sometimes the attorney can take care of it without the business owner being present. In my experience, a lot of times, particularly with small businesses, because the owners are very, emotionally invested, they want to be there for a lot of it. But sometimes it's simply not necessary if it's a purely legal matter, and we already know all the facts, and we don't need to have the business owner there, to ask questions. I would say, generally speaking, a business owner should be there for the first, one or two big hearings, just to sort of, even just to understand the process, because I think it gives them a sense of control. And it's also useful while the attorney is getting up to speed to have somebody that they can ask those questions of. But I think later on in the case, a few hearings in, it tends not to be necessary. Sometimes the court will direct that the owner should appear. It really depends.
And how much would someone has to say, like as a business owner, how much would I have to say on the case? Like, is it something can be imposed on the business owner more than that, what they have a say on it? Or is it, how much can their opinion matter?
With the process?
Yeah.
A lot, actually. So there are certain things that need to happen in every case. So for instance, if you have, I guess the classic example is if you owe money to a bank, right? And the bank has a blanket lien on all of your assets, all the assets of the business is common, right? Then in order to spend money, you need to oftentimes get the bank's permission to spend what's called their cash collateral. If you want to spend money, which you generally need to do to stay in business, you have to file a cash collateral motion. So there are some things that are just automatic givens, right? But then in terms of the progression of the case, I mean, a business owner can assist with the sales process. They have, if there is a decision to sell assets, they assist with that. They assist in the selection of counsel and other advisors. They make the decision in some instances if they want to convert the case. So they are the client. I mean, well, here it's I should be specific. The individual business owner, in the instance of a business bankruptcy, the individual is not a client. The business is the client. And it's an important distinction, because sometimes the interests of the business owner can conflict with what's in the best interest of the estate, which is the goal of the rehabilitation. So there are instances where an individual owner needs to get separate counsel to represent him or her in their business's bankruptcy case.
Okay, so basically the bankruptcy for the business does not affect the personal finances? Could you say that?
It shouldn't. Now, it can in certain circumstances, because the individual business owner might have provided guarantees for the business debts. So it can impact the individual. But if we're viewing it in a silo, right? Meaning, here's the business owner, and they've not commingled their assets. The individual business owner has been being paid hopefully a salary of some kind from the business, and not treating it like his piggy bank or her piggy bank. And maintain all of the corporate formalities, and there's no guarantees that are extended in one direction or the other, and it shouldn't be an issue. But the one thing I would caution is that small business administration loans generally require the owner to personally guarantee. And so, that could be an impact.
Okay, so here's we come again to not commingle your funds. Make sure you follow the rules on whatever the structure your company is at. And I just made a video actually about how to pay yourself as a business owner correctly.
Helpful, very helpful.
Yeah, that will protect your personal finances if you ever have to go to bankruptcy or anything. So yeah, that's really, really helpful. And I was gonna ask you, actually, since you've been this for a long time, do you have any inspiring story where someone was gonna go out of business, and because of the bankruptcy their business was saved? I don't know if you can recall anything, or just few words just to encourage people
yeah, absolutely.
They really need it to just
absolutely. I mean, I think that one instance that I think inspires faith in sort of the bankruptcy process is an individual. A lot of businesses have pre-pandemic, right? They were ramping up their businesses. They took out leases, they signed leases for space that a few months later became irrelevant, right? So they're not making as much money because in this instance, retail wasn't doing that well. Obviously, nobody's leaving their house. No one's buying clothes, except sweatpants, unfortunately. And, the space wasn't necessary and it was too expensive. If a landlord is unwilling to negotiate, and I got to speak in general terms, obviously, but if a landlord is unwilling to negotiate, you can do something called, in a bankruptcy, you can make the decision to assume or reject leases and other types of contracts too. So ultimately, if you sign a 10-year lease, for instance, the landlord, and you decide that you can't afford the space, it's above market, and you decide to get rid of it, you can reject it in a bankruptcy. Or if you have a below market lease, meaning you're paying less than the space is worth in the current market, then you can assume the lease and sell your rights to that lease to a third party. So in this instance, the business owner was able to reject the lease, and it was a 10-year lease. He still had to pay some money to the landlord as rejection damages, but not nearly what he would have had to pay over the 10-year period. As a result, moved into a smaller space and was able to recover.
So in other words, that you end the lease by the court order, and no one can, come back to you and like, you owe me for the next 10 years. Is that what you meant to say? Okay.
Essentially, yes.
Okay,
yeah,
awesome.
Court issues an order authorizing you to reject the lease as not being something that's beneficial to the estate. It's a business decision. This is actually an instance where the business owner is, has an important role in making decisions during the process. He decides, I don't need this space anymore. This is not helping my business. Because remember, we know finances, we don't know how to sell widgets, right? The business owner knows how to sell widgets. And so it's important to have the business owner's trust and partnership throughout the process if it's going to be a successful reorganization.
Oh, that's great. That's great. There's a solution that's just to stay in business and helping people to stay in business, because I know like a lot of business owner now like struggling with cash flow. And this can be really helpful. A lot of people really don't know a lot of, they're afraid, they're scared even to know about it. So this is what I encourage you, feel free like to put any question down below, and I'm gonna leave Adrienne information in the comments below, and then you can ask her any question, or if you need a consultation. Of course, you can help people in your area only, right? Or
that's correct. If you are in New York, so if you're in Manhattan, Brooklyn, Queens, or the Bronx, I can assist you. Like most bankruptcy attorneys, I of course offer a free consultation. Anyone who has any questions and thinks that it's something that they'd like to explore should reach out to me. If it's in one of the neighboring states, oftentimes I know someone that I can refer you to who's reputable. And remember, it's important to know the qualifications of the professional that you hire and to find somebody that you're really comfortable working with, because this person is going to have a lot of personal information about you. You're going to be sharing probably more about your finances than you ever thought you would. And it can be off-putting to some people. It can be a little embarrassing. So you should pick someone that you feel comfortable with and someone who understands the process and whom you trust.
Awesome. So yeah, feel free to reach out to Adrienne or to myself. Like we can do, like, do you mind if we have a lot of questions to come and address it on another
No,
live?
Absolutely. I would be happy to.
Awesome. And also I think you're on YouTube also, so for more information.
Yes, I'm on pretty much every social media platform, and you definitely contact me at through my website at woodslawpc.com, or you can email me at adrienne@woodslawpc.com, and I welcome anybody to reach out with questions.
Thank you so much. I'll leave those information down below this video after we're done. So feel free to reach out to Adrienne with any question. You never know, even if you don't want to like go, you're not sure and you just want to consult with her, just go ahead and send your questions. Use any platform you would like to like message her on, or if you can also reach out to me, I can forward the question, whatever you feel comfortable to do, feel free to do. And if you would like us to talk about anything else in another life, we can certainly schedule another time to talk and to interact with you and see what questions you have. Anything else Adrienne would like to share with people and would like to say the last word before we hop off?
I think I love what you do, because I think it's it's such an important role to make sure that books are properly maintained. And I can tell you that the number of small businesses that really don't invest in professionals the way they should. And oftentimes when people come to me, bad bookkeeping can often lead to a bankruptcy. And it's sad because it doesn't have to be the case, but so many people are penny wise and pound foolish. They don't want to spend the money on a professional like Noura, and instead they try to do it themselves. And then, you know, they come to us and we're trying to do triage. So I always encourage people, pay your professionals, get people who are good, and it can stave off a lot of problems.
Yeah, definitely. Yeah, thank you so much. I really appreciate that you taking the time today to talk to me on the talk to our audience here on the page. Thank you so much. I really appreciate your time, Adrienne.
It was a pleasure. Thank you so much for having me.
No problem. Thank you. And thank you, everyone. Feel free to reach out as we said, and see you later.
Bye.
Bye.